Hey folks, welcome back to the channel. Today's episode is one for the books. The defendant is fresh out of surgery, yet facing charges for assaulting his ex-girlfriend and kicking a police officer in the chin, all while wearing a medical boot. He's trying to convince the court that he's too injured to have harmed anyone. But here's the kicker, pun absolutely intended. The judge didn't buy a single word. She shuts down each and every excuse he throws her way. Cue the tears and the excuses. We're about to get a performance worthy of an Oscar.
Okay. Calling case number 160-451-4901, People versus James Walters. This one from Judge Bryant with a capias. And then I've got case number 240-594-7301, People of the State of Michigan versus James Walters. Counsel.
Lisa Coyle appearing on behalf of both cases on behalf of the people.
Yes, Your Honor. Brandon Bird on behalf of James Walters. My client waives his right to the formal reading, was advised his constitutional right, so we'll stand mute.
Thank you, counsel. The court notes formal reading has been waived, enters a not guilty plea on your client's behalf. Let's take the misdemeanor case first. As to bond, please.
Your Honor, well, I'm going to roll this into my other bond argument, but he has 5 capiases on this matter. This case dates back to from May 2nd of 2016. He has from, I see, July 13th, 5 of them. And there's a couple of forfeits of bond. He does not appear for court. So the people would be asking for a $100 bond with a tether.
Okay, defense.
Your Honor, is there any way that we could address the other case, because depending on how the other case goes?
So I will tell you, after hearing arguments as to the misdemeanor case, I am inclined to a personal bond, because I don't think $100 bond does anything. But I am inclined definitely to a GPS tether because we have a capias history. Mr. Thomas. Hold on, he's gotten himself stuck. I'm sending you a prompt to unmute. Did we? Okay. We'll get to your case in just a moment, Mr. Thomas. Just sit tight. We'll get you in just a moment. Thank you. All right.
Yeah, I agree with Mr. Bird. The bond, other than the tether on the 16 case, is going to be irrelevant compared to the felony charges, what the bond may be. As to the bond and felony charges, Your Honor, this is involving an ex-girlfriend, allegations over cheating. He allegedly put a gun to the temple of her head and threatened to kill her and her kids. Allegedly, he also punched her and grabbed her hair, punched her in the face twice, and dragged her around the house. She then calls the officers and fled the house. As she's outside the house, she flags down the police officers, and during an excited utterance, she tells them exactly what happened. They go to the house because she tells them that he may be escaping out the back door. They see him. They arrest him. He resisted arrest. He drops to the ground. He wouldn't enter the scout car. He's kicking the car doors. He kicked the officer in the chin, causing an injury to the officer. At the time he kicked the officer, he was the defendant was wearing a medical boot, one of those heavy boots. The police subsequently found cocaine in his backpack that he was seen carrying. The girlfriend does locate the gun for the officers, gives that gun over. It's a 9mm. He does have a record, all under HIDA, 2010, 2 counts of CCW, a 2006 disturbing the peace, and a 2012 possession under 7411. As the court is already aware, he is a flight risk because he doesn't show up on that 2016 case. The only reason he's before the court on that case is because he got arrested on this case today. Your Honor, so not only there is a flight risk because he does not come to court, but there's also a danger to, her name is Ms. Walls. This is an ex-girlfriend, and not only that, she left that house, she left the house with her child inside. So she did fear. That tells me something, that this woman was in fear, that she would leave her child with someone who put a gun to her head and call the police, because that's the way she felt that she could get herself to a place of safety. And so based on that, Your Honor, even though I do not see an assault of record for him, I do see gun charges in his past. I do see this is everything that the complainant says. And look at the way he was acting toward the police upon arrest. He kicked an officer in the face. So based on that, this man was out of control, whether there was something regarding those drugs or whatever, the allegations of cheating got him riled up. This man got out of control, was with this woman, put her in fear for her life and her kids, and also was absolutely out of control with the police officers. So based on that, Your Honor, I'm asking for a $50,000 cash assured tether house arrest. I do not see them living together. This was a dating relationship that is over. They were dating since 2018. So for that reason, I'm asking for no contact as well. Thank you.
Thank you. Thank you. Okay, Mr. Byrd.
Start with the basics. 37-year-old, lifelong resident, Yana, 2 children, indicates to us that he's not on probation or parole, no pending cases. One big thing that stands out to me is the fact that we have officers saying they would kick, punch, and don't have a resisting and obstruction charge against the police officer, Your Honor, which usually we'd see with that much detail and description that's in this report, or maybe I don't know. I'm not about to go there, but we don't have a resisting obstruction charge, Your Honor, and the officers say they were kicked, punched, and other things. Also, when it comes to the felonious assault, now we just can't run the story together and make it seem a certain way. Now, when it comes to finding the gun, when the officers were there that day after the incident happened, no gun was found. When they come back the next day, that's when the complaining witness happens to find the gun that belongs to him. Which I'm not saying it can't be possible, but I'm saying that's something that stands out to me, that no gun was found during the search, right after all this was happening, in which the complaining witness claims that he held a gun to her temple. She flagged the police down, and they were there that night and couldn't find the gun. But they come back the next day to talk to the complaining witness to receive a statement. And that's not when they find the gun. That's when the complaining witness gives the officers a gun that she said she found she found. And that was his gun. So that does stand out to me, Your Honor. Those couple of things stand out to me in this matter. I do understand these are very assaultive allegations. I do look at it a little bit differently than Ms. Coyle about someone being that scared that they run out the house with their child if somebody's threatening them and their children. I look at it, and maybe this is just from my standpoint. If somebody's threatening me and my children, the first thing I'm gonna go for is my children, regardless of the situation, Your Honor. So I can't say that we could pull we could pull that fact about it. Like I'm not saying the statement can be true, but that's not why we're here, and that's why they got preliminary exams and trial right now. But I'm saying those sort of things stick out to me when we have reports in front of us. We have police getting assaulted, but no resisting obstruction charge. We have somebody that claims to had a gun put to their head, but the police don't find it right after fresh when the incident happens. But we get this gun from the complaining witness, handed to the complaining witness, in which the police couldn't find with their search, and which the police still didn't find when they came. It was handed by the complaining witness. So there's a lot of things that stand out to this report, which I do look at when it comes to the validity of everything that's going on and the validity of statements. But I know that's gonna be weighed at a different time, Your Honor, but respectfully, my client understands that there's gonna be no contact with the complaining witness. No contact with the complaining witness. Doesn't stay with the complaining witness, Your Honor. And respectfully, we're gonna ask this court potentially for a personal bond. If the court's not inclined to a personal bond, then at least a reasonable and low 10% bond seems fit by the court, where my client can have a chance to pay it, get out. And if the court's concerned, at least he'll have some skin in the game. But respectfully, we're gonna ask for a personal bond in this matter, Your Honor.
Thank you.
Your Honor, if Mr. Byrd, he would like, there is a picture of the photograph with the officer with the cut on his chin here. I didn't feel there was a need to extend that.
In the investigator's report, it states that due to officer sustaining injuries as a result from the kick to the chin, evidence tech took photographs of the injury. So that's, that tells you. What I find odd, however, is there's no reference whatsoever to any injuries as to the complainant. No one observing any injuries to the complainant. Do you see that in the report?
I do not see any, exactly what you said. This is alleged to have just put the gun to her temple, but she does say he pulled her hair and punched her in the cheek. But there were no noted. And I think I read, let me double check, but I read her statement. And her statement indicated she did not go to the hospital. I'm double checking right now.
If you punched her in the cheek twice, they don't have any injuries listed there.
And also dragged her around the house, Your Honor.
It said,
sorry?
She also says he dragged her around the house.
Yes, I saw that. Yes.
Okay, question. Did you receive injuries? Answer, he punched me and pulled my hair, but I didn't go to the hospital. Question, did you seek medical attention? Answer, no.
Okay, I mean, a person doesn't have to seek medical attention. We don't always have injuries resulting. Okay,
correct.
All right.
Yeah, can I address my client real fast, please?
Yes.
Mr. Waters, can you please not make any gestures, raise your hand, or speak at this moment? Everything you're saying is being recorded to be used against you. Right now, I would advise you to exercise your right to remain silent and not make gestures, please.
Yes, sir. I was just wanted you to bring up my surgery, but I just had surgery 2 days ago. So it's like, how can I do all this? I only have one leg. I just left the hospital for foot surgery.
Okay, well, sounds like that was addressed in Ms. Goyle's argument. All right. Due to the allegation of the firearm being used in this case, due to the fact that a threat to do greater harm was purportedly made, while there was not a firearm found during the search, there was one later provided by the complainant stating this is the one that was used. I do have concern for her safety and the children's safety, given the alleged threats to do greater harm. Bond is set at $30,000, 10%. If you're able to make the bond, sir, you must be fitted with a GPS tether before you leave the jail. That tether requiring, allowing you to go to work and to work only. Next court date is going to be September the 23rd for bond review hearing in McConaughey's courtroom, 26th for probable cause conference, October 1st for preliminary examination, the latter two in front of Judge King. You are not to purchase or possess any firearms or other dangerous weapons during the course of the bond, nor are you to have or attempt any contact with the complainant. That means no verbal contact, no written contact, no contact through third parties or social media. Any attempt at contact would be considered a violation of the conditions of the bond. I will say for the record, One of the other things that influenced my decision to impose a cash bond in this case is that I have not one person accusing defendant of acting irately, but 3 actually accusing defendant of acting in an irate manner, lending some credibility to the complainant's allegations. So that's where we are. Sir, it is your right to speak at your hearing. It is also your right to remain silent. Your attorney has advised you to do that, but it is your absolute right to speak at your hearing. If despite his advice you wish to address the court, you may do so.
I understand that, Your Honor. Your Honor, I just left surgery not even 3 days ago with the same woman that beat on me and made these lies, allegations against me. I have screws in my foot. I cannot move or stand on my own. I need crutches to walk around. There's no way I could give all of this violence to this woman. I don't even have the strength to do it. This is the same woman that I've been with for 13 years.
We don't just have one woman saying that you did this. We have an officer saying that you used the boot on your foot where you had surgery to kick him in the chin.
Your Honor, once I seen what she was doing to me, yes, I broke down. Once I seen that she was trying to say,
please, and that's not, please.
I broke down, Your Honor.
You're making statements that's hurting you. At this moment,
Right,
you're making
thank you.
statements that, Your Honor, can we continue to bond on the misdemeanor case, please?
We need to address
The $100, 10%.
Yes, Madam Clerk, just change it, please. $100, 10% on the misdemeanor. He wants credit.
Are you going to
All
put a tether on that as well, Your Honor?
He's got a tether. Yes, he's got a tether on this case. Tether to work only.
Thank you.
Please make sure that's reflected, Madam Clerk. I thought I said it. Make sure I wrote it, please.
That boot defense didn't quite kick in the way he hoped. Despite the tears and attempts to paint himself as too injured to cause any harm, the judge saw right through it, giving him a $30,000 bond and a reality check. And nothing justifies kicking a cop, boot or no boot. So what do you think? Was the boot defense plausible, or was he doomed from the start? Let me know in the comments, and don't forget to like, subscribe, and hit that notification bell for more gripping courtroom moments. Thank you for watching. See you in the next one.